Hello and welcome or welcome back to my channel. My name is Professor G, and for those of you who don't know me, I'll give you a little bit of my background. I am a law professor and historian, and my area of scholarly research is in the antebellum slave laws and slave codes that sustained the slaveocracy, the slave society that was the antebellum South and eventually became the Confederate States of America. I do this because I believe it is very important to end this absurd Confederate worship that you see that still continues today. And in recent events, with President Trump wanting to return the names of many military installations back to the names of Confederate generals, I felt even more charged in my mission to expose the antebellum South and the Confederacy for what it really was, a slave society, not simply a society with slaves. Everything about the South was based around the institution of African slavery. And while you hear many arguments that not every white person in the South owned slaves, that is 100% true. But every white person in the South benefited from and was highly invested in the institution of African slavery, whether that's hirers and overseers who worked for plantation owners, whether that was smaller farmers who grew crops that were bought by plantation owners in order to feed the enslaved, whether that was from blacksmiths and other lower mechanical sort of working, lower class white individuals who also sold their wares and did work for plantations. And of course, no matter how lowly you were as a white individual in the antebellum slaveocracy of the South, you were still considered to be racially superior to anyone of African descent who was enslaved or who happened to be a free person of color. So you had a vested interest in the continuation of the system of slavery, of African slavery, because even the lowest level of white person was still considered higher than any of the enslaved or any person of African descent, because this was a racially based system of slavery. And go watch some of my previous videos where I explain the difference between this and Roman slavery and why the racial aspect of it made it perhaps the worst form of slavery that has ever existed on the planet in the corpus of human history. So to that end, to try and stop this Confederate worship that you see going on, I try and post videos taken from Supreme Court cases of antebellum slaveholding states, so the state Supreme Courts, on various issues dealing with the enslaved. And I take this from some of my own scholarly research and publications that I've done, and I put them on YouTube for you to see the mental gymnastics that the Southern legal system, the antebellum legal system, the slaveocracy, had to jump through when trying to justify the enslavement of human beings. How they had to juggle and argue and fight with the idea that a slave was to them first property, but also had a mind of their own as a human being. And how do you justify it? How do you balance that? What do you do? How is someone, something, both a person and property? And to watch what these courts tried to do and how they tried to justify it is truly disturbing and sickening. And also, you'll hear many people argue that slavery, of course, wasn't that bad, that there were laws protecting the enslaved. And while that is true, there were laws on the books protecting the enslaved. These laws were seldom followed, and if and when they were followed, it was more to protect the financial interest of the owner, of the master, than to protect the physical security of the enslaved. And in fact, when these laws were broken, or when a civil suit was filed against someone for destroying the property of a master, meaning killing or seriously maiming the enslaved, the courts did their best to, while they understood they might have to punish that person, to leave the door open for the continued submission of the enslaved to the enslavers. What I mean by that is many of these courts acknowledge that slavery could only exist if masters had absolute power over their slaves. Well, how do they have absolute power and still get away with murdering, maiming, or crippling the enslaved? Well, the courts had to navigate that legal rapids, and they came to some of these crazy conclusions like the one you're going to see today. So this is, again, the Alabama Supreme Court. This is Nelson v. Bondurant. I hope I'm saying that correct. Probably not, but it is what it is. And this was in 1855. So the facts of this case is that Sam was an enslaved person. He had been hired out to a man named Samuel Nelson by the Bondurant family for the year of 1850. Sam apparently disobeyed orders and left the plantation without Samuel Nelson's permission to visit his wife. How dare he, right? So Sam went to go visit his wife. Sam was returned to the Bondurant family where John F. Bondurant, apparently the patriarch, whipped him with switches, gave him 30 lashes, and then sent him back to Nelson, the person he had hired Sam out to. So Sam escaped, was caught, was returned to his master, who whipped him 30 times with a switch, right? Which is all that it says. So if you live in the South or you grew up in the South, you know switch is used like a stick, but this hurts, and it could even cause death, right? If it was used, you know, depending on what this switch actually is, and he was lashed 30 times with it, then sent back to Samuel Nelson. Now, Sam, since he's a human being, even though he's enslaved, was obviously really disturbed by all of this. So when he gets back to Nelson, Nelson wanted to punish him as well. And he resisted. So Sam didn't want to be punished by Nelson after already being lashed 30 times with a switch. So he attacked Nelson with a knife. And he ended up cutting Nelson and cutting Nelson's wife, right? Now, Nelson and others subdued Sam, and during this scuffle, he suffered a head injury when he fell, but he was then tied up. After he'd fallen and suffered a head injury, he was tied up, whipped again, and then beaten by Nelson and 4 others who were with Nelson at the time, right? So, the Supreme Court of Alabama looked at this and said, the issue here is what constitutes cruel and barbarous punishment. You see, the trial court actually instructed the jury that if the defendants whipped the slave while he was tied, and that act contributed to his death, so Sam died in all of this, right? So in the trial court, the judge told the jury, if they tied him up, and while he was tied up, they whipped him, and that whipping and tying contributed to his death, then they could be held liable, regardless of whether the act itself was illegal or not. Now, the Alabama Supreme Court, amazingly enough, had a problem with this jury instruction. The court tried to pretend that it was going to protect the lives of the enslaved, and in one part of its opinion, the court said, he has the right to correct, but he has no right to be barbarous or cruel, and if the punishment inflicted, when considered with a just regard to all the circumstances, is either the one or the other, it is denounced by our penal code. So what the court was saying is, if what they did was barbarous or cruel, then it's a crime, and then they could be also civilly liable for the death of the slave to Sam's owner for recompense, to pay him back for the value of Sam. But we have a problem, don't we? This raises some questions. Like, for example, what level of pain or injury qualifies as barbarous? How many lashes? With what type of instrument? On what body part? Does being tied and being whipped after receiving a head injury make this cruel or barbarous? Does the past behavior of the enslaved justify a harsher punishment? Now, the court here, and watch what they do, just like in all the other cases, the court offered no concrete metric or examples, and instead said that contextual factors, such as the offense, the character of the enslaved person, and the need for discipline, as well as what was considered normal and appropriate forms of punishment within the Alabama slaveholding community, right? All of this. So it inherited this subjective standard and gave broad discretion to juries and, in some cases, judges to decide whether or not this was cruel or barbarous. Now, the other thing you got to remember is the juries were going to be composed of whom, right? Most of the time, these civil suits or even criminal actions were not done by the master, the wealthy 1 or 2% of Southern antebellum society, but were rather done by people who the slave was hired out to or the overseers of the plantation. So these overseers and hirers would often do things like this, brutally beat, maim, cripple, and kill an enslaved person, and then the masters would sue them for damages because you destroyed my property, however horrible and hard that is to say. Well, the juries were mostly full of other whites of the same social class of these hirers or of these overseers. People who had a vested interest in, one, the slave society continuing so they had work, and two, protecting the interests and the rights of the overseers and not having their own actions when they were dealing with slaves, whipping, beating, cruelly maiming, and killing them, and them not being liable in the same situations. So, of course, the wagons were circled. When you give the juries the right to decide what is cruel or what is unusual or barbarous when it came to actions committed against slaves. So remember, the trial court instructed the jury that if the defendants whipped the slave while he was tied, and that act contributed to his death, they could be held liable regardless of whether or not the act of tying and whipping itself was illegal or not. Well, the Alabama Supreme Court rejected this. They overturned the jury's instructions and kicked it back to the trial court, saying that liability must depend on the act being illegal, meaning the act of tying and whipping and the death, that itself must be cruel or barbarous. Not just the fact that death resulted. Death is not the question here. This is the scary part. The death of Sam, the death of the enslaved, was not the issue. The issue is whether or not the tying and the beating him after his head injury was cruel and barbarous. Because if not, then they are not liable civilly or criminally. They didn't do anything wrong. But the crazy part is that the court actually said it's not the fact that death resulted. So if I had a whip, a bullwhip, and I whipped an enslaved person to death, and I went to court, and that court looked at me and I said, Your Honors, or jury, the slave was disobedient. The slave refused to submit, as you've seen I've said from previous cases. So I took a common method that is used here in Alabama, the whip, and I repeatedly whipped this slave until they either surrendered submission, which they didn't, and they ended up dying as a result of this beating. The court would say that is absolutely fine. It's not the death, it's whether or not the whipping, the beating, was cruel or barbarous or not. And that will be decided by a judge or a jury based on acceptable practices in Alabama at the time, the condition and disobedience of the slave, and my own testimony as an enslaver. So merely contributing to the death of an enslaved person was insufficient for liability unless the method or the degree of the punishment violated acceptable norms for punishment of enslaved people in Alabama. So again, who determined legal norms? Who determined what was cruel or barbarous? The court made it clear that tying up a slave and whipping that slave to death did not necessarily amount to cruel or barbarous punishment, since that is what happened in this case. Instead, they kicked it back to the trial court for the jury to determine, based on the character of Sam, based on the testimony of the defendants, based on what is considered normal and acceptable practice for slave discipline in Alabama, to consider all of that and then decide if they were liable based on whether or not it was cruel or barbarous. And guess what they decided? I'm not going to tell you, but guess what they probably decided? And you see how it even doesn't matter what they decided. Because what matters is that the court, through its decision, carefully constructed this to leave open the possibility of future beatings and maimings and cruelty, as long as it was done under the acceptable norms for disciplining slaves at the time. And that's just terrifying. So again, this worship, to tie it all together, of a society, of a country that its own founders acknowledged existed on the principle that, quote, the Negro is not on the same level, not a direct quote, as the white man. That's from Alexander Stephens. That he is inferior to the white man. That's in the Cornerstone speech. Or the fact the Confederate Constitution enshrines forever the institution of African slavery. To defend that nation and to defend that society before it became a nation that existed entirely around the institution of African slavery is perhaps the most racist thing that anyone can do. It is not about heritage. It is not about history. The heritage and history of the Confederacy and the antebellum South is one of absolute total racism, dominion, and subjugation of African people, and white supremacy, and an entire society and civilization based around white supremacy. And that is historical fact. So as always, remember to like, subscribe, share, and I will see you for the next video.